Okay, good afternoon everybody and welcome to the Better Business Learning series. This installation for today's webinar is all about casual employees, focusing on casual conversions, statutory entitlements and some other challenges that have popped up over recent months in this space. We've still got a few participants that we're waiting to log on. So I'll just get started with a bit of the introductory stuff about myself, and when we've got a few more locked in, we can get underway on the content. So thank you for joining us today. As most of you would know, my name is Malcolm Campbell. I'm the Managing Partner of Dooley & Associate Solicitors. I've been working in law for 18 years here in Sydney, helping a diverse range of clients navigate various legal matters relating to their business, and quite a focus, particularly over recent years, in the employment law space. We decided to create this second part of our Better Business Learning series on the topic of casuals because, as no doubt everybody has heard and seen over recent times, it is a very topical issue and it is a difficult area for almost all businesses. If you're employing people, you've no doubt grappled with this issue from time to time. So what we're going to do is we're going to cover off on 4 main areas relating to casuals today, and we will have some time for questions at the end. I won't be stopping for questions as we go, as this is a one-way webinar. You can hear me, but I can't hear you. The best way to ask questions is in the Q&A sidebar or panel that you can set up on your screen on the Zoom function there for the webinar, and I will answer those at the end of our time together today. If we are inundated with questions, I will by all means get in contact with you individually. Okay, just looking, we've got about as many people as I think we're going to have connecting with us today or joining the webinar, so we'll get underway on the webinar now. All right, let's just jump straight in. So we'll be looking at a snapshot of casual employment in Australia. We'll have a look at the recent case law around casuals and statutory entitlements. We'll look at the casual conversion rights, and then lastly we'll spend some time on the relatively new family and domestic violence leave, which of course includes casual employees. All right, so I think really one of the reasons why there is such confusion and difficulty around the concept of casual employment in Australia is because of the very fact that there is actually no strict definition of what a casual employee is. So when you have a look at the Fair Work Act, which 99% of employees in Australia are now covered by, there's actually no definition of a casual employee. That's therefore a difficult starting point for people. If you're trying to figure out, well, is this person a casual or not, you're not given any assistance by the Fair Work Act. Those of you familiar with employing people pursuant to our modern awards will probably also be aware of the fact that most of the awards simply state that a casual employee is an employee engaged as such, which is a circular definition and completely useless for employers in trying to figure out whether or not the person they are engaging is as a casual or some other type of employment. So really the 2 sources of information that is most helpful for employers are through the Fair Work Ombudsman, who are the government body charged with the obligation to assist employers and employees comply with their industrial relations obligations, but also then the case law around this particular issue. Jumping down to that case law section or definition there on the slide, you can see that casual or a casual employee is an employee who has no firm advance commitment to continuing an indefinite employment or an agreed pattern of work. And you will see that that agreed pattern of work issue is actually quite important and something that we'll touch on later in the presentation. So the Fair Work Ombudsman then sort of gives you a lot of examples and I guess a fleshing out of what that means. And it's things like you have no guarantee of hours of work. If it's a true casual, they're working irregular hours. There's no paid leave like sick leave or annual leave. And often the employment can be ended without notice unless it's required by some other instrument. Typically speaking, true casuals will receive loading, which compensates them for the fact that they're not accruing these statutory entitlements, paid entitlements. But that's a bit of a misleading element to establishing whether somebody is a casual. Just because somebody receives the loading doesn't automatically make them a casual. So what I thought I would do in preparing this presentation is having a look at the statistics around casual or the instance of casual employment in Australia, because there's been a lot of media airtime over the last 12 to 18 months about casual employees and how our workforce is being overrun with casualisation and those sorts of things. It's difficult always when trying to compile statistics and figures to make sure that you are comparing apples to apples. And so I had a look at the types of information that the ABS collect, and I've also had a look at some of the reports that the Australian Broadcasting Corporation compiled late last year in response to a lot of the political commentary that was going on at the time when these changes were being debated. So for the purposes of data collection, the ABS actually distinguishes between employees with paid leave entitlements and those without. That's what they distinguish as a casual for the purposes of the collection of their statistics. And because there is that no one singular statutory definition of a casual, that's how they determined they would collect their data. And then during all of the various debates that were going on in Parliament last year, the ABC used the ABS labour statistics to compile a report, a time-based series report, to look at the rate of casual employment in Australia. They partnered with a professor down at the Melbourne Institute of Applied Economic and Social Research, and they put together this report which shows that basically in 1997 we had 24.2% of employees in Australia were casuals. Fast forward to 2017, it was only 25.1%. So we have this huge debate and argument going on that we've got an over-casualisation of our workforce, yet over that particular 20-year period, the rate of casualisation had only hit a high of 25.7 and then a low of 23.7 in that period, but really it's only gone up by 0.9%. That's right, yeah, 0.9% over a 20-year period. So on those statistics, it certainly isn't borne out that we have had this huge jump in casualisation of the Australian workforce. However, I think that there is a little bit of misleading information in relation to those statistics. I think that there is a significant growth in what or how casual employees are being used, and that is what has led to this debate around the casualisation of our labour force. I think, in our experience, that many small to medium enterprises think that it costs a lot less to employ casuals compared to permanent employees. I think they look at the indirect costs in relation to not having to, in their minds, manage performance as closely because they feel like they can move someone on without notice. I think that they are unaware of the fact that after meeting certain criteria, they still have access to things like unfair dismissal, and there is a very common misunderstanding that casual employees are also entitled to long service leave in some circumstances. So if we have casuals being engaged for probably improper purposes or through ignorance or misunderstanding, we are probably going to get to a perverse or an unintended situation where casuals have been employed to try to get around other barriers to employing people. Interestingly, businesses seem to be prepared to pay the 25% loading up front to get around the indirect costs that they perceive, because they believe, for whatever reason, that is going to be cheaper and easier for them to deal with an employee in that manner. I think if you do the math, I don't think it actually works out that way. And the reason really, in my opinion, as to why this has now become such a significant issue, and obviously something that has caused a change in our laws over recent times as a result of it becoming so significant, is because when you look at the statistics in Australia, as you can see on the screen there, we have, 90-something%, if I can do my maths quickly enough, 99% really, if you get rid of the over 200 people category, over 99% of all Australian businesses employing up to 199 employees. If we really focus at the small business end of the scale, that's a very, very large percentage of Australian employers, Australian businesses, who, in my opinion, probably have a misunderstanding as to the appropriate use of casual employees. And what I think that has meant is a steady growth in long-term casual employees or regular casual employees. There's a few different pieces of terminology used in the rest of the presentation, which reflects the wording in awards and case law that has come about as a result of this. So we have a very large number of employers engaging more casuals, so the overall percentage of casualisation as a workforce hasn't gone up, but it is quite clear that the casuals that are being engaged there is a significant growth in the long-term casuals within that statistics. And that's where and why we have led to a number of these changes, all culminating, strangely enough, throughout 2018. Some of you may have heard of the Workpac versus Skene case, which was determined in August last year and has had very widespread ramifications. The situation basically was an argument around whether or not somebody who'd been engaged as a casual, whether or not they were also entitled to accrued statutory entitlements such as annual leave at the end of their employment. So we have a situation where the ultimate decision was that the particular employee, Mr. Skeen, was entitled to annual leave, notwithstanding the fact that he had been engaged as a casual employee. Now, that might sound like a perverse outcome, but I'll step you through how that all came about, and you may recognise very quickly some commonality in this case and what your businesses might be doing or might have done in the past in relation to casual employees. So Mr. Skeen was engaged by WorkPac, who were a labour hire company, and he was sent out to or located at one of WorkPac's clients, a mine in central Queensland. Now, he operated, he was a truck driver, and he was engaged over a 2-year period to work a set roster, which was 7 days on, 7 days off, set a year in advance. He worked with the same crew, and they were a mix of direct employees and labour hire employees. He worked the same hours every shift, and he was your typical, what you would call, fly-in, fly-out employee. His employment was ended after the mine no longer required him, and then when the labour hire company didn't require or could not find him any additional work, his employment with WorkPac, the labour hire company, was also ended at the same time. Now, in terms of his engagement by WorkPac, his contract stated that he was a casual. He was paid a flat rate per hour, and that was expressed to include, and you can see in bold on the slide there, a loading in lieu of leave entitlements. He submitted timesheets, he was paid by the hour, and his contract allowed for termination by 1 hour's notice. So all in all, it seemed like a very standard engagement of a casual employee. However, he asserted at the end of his employment that he was entitled to both notice and annual leave under the National Employment Standards within the Fair Work Act. Now, the court upheld or reaffirmed the numerous decisions beforehand in terms of the definition of a casual employee, and that they are characterised by having no firm advance commitment to continuing an indefinite work according to an agreed pattern of work. And you'll notice the word mutual in brackets in the definition there, and that is because one of the concepts of true casual employment is that you can be offered a shift as a casual employee and you're under no obligation to accept it. So that is a very important part of the distinction between a casual and a permanent employee. If a part-timer is engaged to work 3 shifts a week and it may even be that it's set days per week, then they are obliged to work those shifts. They can't turn them down. That is not the case with a true casual. So it is that the court looked at in terms of the essence of whether or not he was a casual employee. So when you had a look at the terms of his engagement, and I'll flick back one screen, he was engaged in a manner where he knew his roster a year in advance. That certainly seems to tick the box of having a firm advanced commitment to continuing employment, and it certainly is an agreed pattern of work, working the 7 days on, 7 day off roster. He's working with the same crew, same hours every shift. It's quite clear that he did fit the definition of a permanent rather than casual employee. Moving on to his contract of employment, however, it said, you're a casual. And it said, you get a loading in lieu of leave entitlements. So he wasn't accruing leave on their books, and he was getting a loading in lieu of the fact that he wasn't accruing those entitlements. However, the court determined that where an employee is in continuous employment, they're not within the scope of the expression casual employee for the purposes of, in this case, Section 86 of the Act, which is all around annual leave. So what they actually said was, well, he had regular patterns of work. There was no uncertainty over his employment. It wasn't intermittent. It wasn't unpredictable. He has mistakenly been referred to as a casual employee, where really he is a permanent employee. And accordingly, he was granted or he had an order in his favour to receive both the notice and annual leave that he was seeking. So that immediately begs the question of, well, hang on a minute, doesn't he get both the loading then throughout his employment, and then at the end he's getting his annual leave that the loading was supposed to be in lieu of? And the court addressed that matter, I think, in an interesting fashion, where they said, assuming that he was paid a casual loading, and I'll come back to that wording in a minute, but assuming he was paid a casual loading, which at least in part covered the accrual of annual leave, then it may be said that he was being paid twice for the same entitlement. However, the court said if he was paid a casual loading when he shouldn't have been, because he wasn't really a casual, then it's not a legitimate basis for trying to get out of, so to speak, paying the annual leave, which was the case of work. That was one of WorkPac's argument. So that's how they tried to address that issue of double dipping. They did also make an observation that an employer may be able to make a claim to set off against the casual loading paid if they then are unsuccessful in establishing that they were a casual and therefore they're entitled to the annual leave. They may be able to offset the amount that they have paid as the loading. But one of the real stings in the tail for the WorkPac case was when they tried to run that argument, the response was, well, you can't actually determine exactly what he was paid percentage-wise or dollar-wise as the loading in lieu of accruing the statutory entitlements. Because if we go back a couple of screens, you'll note that his contract simply said that his rate of pay was expressed to include a loading in lieu of leave entitlements. It didn't say how much loading, either in dollars per hour or as a percentage. So it was impossible for WorkPac to actually run their offsetting claim because they couldn't define the quantum or the amount that should be offset. It was just expressed, your rate of pay includes a loading. So the ultimate outcome was he's not a casual employee and he's therefore entitled to the annual leave and notice entitlements under the National Employment Standards. So you can understand that that probably sent a significant scare, particularly through the labour hire industry and those that used labour hire services. So there needs to be a number of urgent things that are done by employers who use casuals in this matter to have a look at what they're doing. And it's not necessarily as simple as not employing casuals, because often people like being engaged as a casual because they like the upfront payment of the loading rather than accruing paid leave. It's an easier way for some employees to effectively get themselves a pay rise. So really what we recommend that employers do is have a look at their documents and their systems of work and their work practices in relation to the engagement of casuals. How long in advance are you setting your rosters? What sort of commitment are they given? Whilst it might be a rarity for many businesses, setting a roster 1 year in advance is almost always going to result in there being a systematic and regular pattern of work there. So you might even if you are, from a managerial perspective, setting them long term, you may not publish them on that basis. You may publish them on a monthly or fortnightly basis rather than a 6-monthly or annual basis. You might also want to have a look at whether or not the contract of employment and the related pay slips clearly attribute an identifiable amount to be paid as cash in lieu of them accruing the right to those paid statutory entitlements. So it would be best to express that in their contract. You would set out what their base rate of pay is, then you would set out what their loading is. Typically it would be stated to be 25% of the base rate in lieu of not accruing the statutory entitlements. On top of that, it would be very helpful that pay slips are set out in this manner so that you can easily quantify exactly what was paid instead of the person accruing those entitlements. And then I guess the final thing to have a think about as well is whether or not there is actually really any advantage in engaging someone as a casual if they're being engaged as a regular and systematic employee. If somebody knows their roster 12 months in advance, what is the benefit of having them engaged as a casual? You are promoting them not taking leave when they are unwell, not taking rest and recuperation time. You're introducing them, working when they probably shouldn't due to illness, therefore affecting their colleagues and the like. You are paying the cash up front each payroll cycle in the form of the loading, rather than maybe amortising that out over the period of engagement. And you also have the situation where even though you might have to pay for example, annual leave as and when they take it, you are getting an indirect benefit from that. You're not avoiding things like long service leave or unfair dismissal. There's really no benefit there when engaging casuals over a long-term period of time. So they're the sorts of things that need to be considered in the light of the workpack and scheme case. It actually caused such an uproar in the industrial relations circle that very soon after, particularly in legislative terms, only months after the case came out, the government actually introduced an amendment to the Fair Work Act regarding the issue of offsetting loadings that were paid. Now, it's important to understand that this offsetting right is really only beneficial in answering a claim that has already been made by an employee for their statutory entitlements if they were in a Mr. Skeen situation. It doesn't prevent the claim being made in the first place, so that's something that should be made quite clear from the outset. But what they have done is introduced an amendment to the Act such that if you do as an employer get caught out in a situation where you've had someone engaged as a casual, you've paid them an amount being the loading amount that is clearly identifiable as an amount to compensate for not having one or more of the relevant statutory entitlements, and they were actually, in fact, a employee other than a casual for the purposes of the NES, like Mr. Skeen, and then that person makes a claim to be paid an amount in lieu of one of those entitlements, then the employer may seek to have the loading amount taken into account when the court is determining, not the individual parties, but when the court is then determining any amount payable by the employer in lieu of those entitlements. So it's obviously had such a drastic impact that the federal government have swooped in and introduced this amendment to try and prevent the double dip scenario. But of course, you've got to comply with, or you've got to meet all of those bullet points in the slide there in relation to being able to argue or successfully apply the offsetting argument. So again, it makes it particularly important that the documents you are using to engage casuals and record the amount that they are paid, i.e. their pay slips, clearly identify the loading that is paid in lieu of them accruing the entitlements. Okay, moving on to casual conversion. What is casual conversion? Well, it's the transfer of an employee's employment status from casual to permanent. Now, permanent can be full-time or part-time. I often hear people saying permanent part-time. That's a bit of a tautology. Part-time denotes permanency. It's just something less than 38 hours per week. So what has happened with casual conversion? Well, there's been what's called a model casual conversion clause inserted into 84 of our modern awards. There's been a modified version of that clause inserted into 14 other awards, and there were already 28 modern awards that contained a casual conversion clause. They remain unchanged. And so some of you, particularly, for example, if you were operating in the manufacturing industry, you would already be well aware of these casual conversion rights. So when is an employee entitled to casual conversion? Well, and it comes back to one of those definitions I was talking about before of the regular casual employee. To be a regular casual employee, you must have worked for 12 months or more, and your hours must be, I guess what you could say, regular and systematic. They must be on an ongoing basis and which you could continue to perform, or the employee could continue to perform as a part or full-time employee without significant adjustment. So if you were doing 38 or more, you would be applying to convert to full-time. If you're doing something less than that, you'd be applying to convert to a part-time employee. The right is continuous. So it's not like you have a window of time where the employee can elect. It's once you become the regular casual employee, and whilst ever you are the regular casual employee, you have that right to elect to convert to become a permanent employee. Note, as I mentioned before, some modern awards already had a casual conversion clause. It is only the model clause that has the 12-month period. Some will have a 6-month period to become the regular and systematic employee or regular casual employee. So make sure you check the award that applies to your particular workplaces. And of course, there is more than one award that may operate in your workplace. So you might have a perverse situation with certain categories of employees only have to be there for 6 months, and others might need to be there for 12 months to effectively have the same right to convert. Is it automatic? No, not in the model term in the modern awards. You have a look at your awards. As I said, the manufacturing and associated industries award requires the employer to give the employee notice within 4 weeks of them having worked 6 months to then have that right. So you just need to look at each and every award as is applicable to you. Can you refuse the request? Yes, it is possible. And if any of you out there have dealt with requests for flexible working arrangements under the NES, you'll be familiar with the concepts that need to be applied in order to refuse a request. It's very much similar to that process. You have to have shown, so the request has to be put in writing to convert. You then need to consult with the employee and you need to respond, providing that refusal in writing within 21 days. And the basis upon which you can refuse is if there are reasonable grounds to do so. And that's the same as the flexible working arrangement request provisions. What does that mean? Well, there's no one hard and fast answer to reasonable grounds. It is clearly going to depend on the type of business you are, the size of business you are, the particular role the employee is in, whether or not significant changes need to be made to enable them to convert to a permanent role, and so on. So you need to have some consideration to those subjective issues. You also need to have a look at the relevant awards, because some of them will have some criteria around what may well be considered to be grounds for refusal. In the model term, the employee has the right to challenge a refusal using the standard dispute resolution provisions in the relevant modern award. So you could end up before the Fair Work Commission to determine something like this, although I imagine that that would be quite an extreme outcome, and it's not something that happens frequently, certainly not in our experience. What records? This is an interesting part of the model term. You need to keep records of the request having been made in writing, and if the request is granted, you must record the details of the conversation and consultation and agreement to convert. Bizarrely, the model term does not require you to keep records if you refuse a request, but common sense would dictate that that's probably the most important circumstance, that you would keep copies of documents and communications around a request for conversion that is refused. When does it take effect? If it's agreed to, it takes effect from the next pay cycle unless some other terms are agreed between the parties. So what does that mean? What should you guys all be doing now if you haven't already actioned this? Well, the standard provision under the model term is that you must provide new casual employees with a copy of the casual conversion clause from the applicable award within the first 12 months of their engagement, their first engagement to perform work. Well, what does that mean? What's the definition of a new casual employee? Well, basically, the cut-off date for that was October, 1 October last year. So anyone that was employed as a casual as at 1 October last year needed to have been given notice by 1 January 2019. So if you had casual employees in your workforce as at 1 October last year and you have not yet given them the copy of the casual conversion clause, I highly recommend that you do that now. You should do it in a manner where you can keep a record of it. Even though you have missed that deadline, it is far better to have actioned it as soon as you became aware of it, rather than bury your head in the sand in relation to it. So think about how you might be able to get that out to all of the relevant employees and have a very good record of that. You might also want to think about some further things that need to be introduced in your processes and procedures in relation to the engagement of casual employees these days, in terms of the obligations around casual conversion. So you probably would want to diarise the 12-month anniversary of casual employees, so you can make sure that you have provided that notification of the clause within that period of time. You might want to have a look at whether your payroll system can deal with casual conversions, because you're going to have to make sure that their period of service starts from when they first started, the change in pay rates, and so on and so forth. You may also want to have a broader look at whether or not long-term casuals actually should be converted to casual employment roles in the first place. And what I mean by that is, do you really need to engage them as casuals, or would it be more appropriate to engage them as permanent employees from the get-go, and therefore mitigate the risks associated with work pack and scheme scenarios, missing casual conversion rights and obligations, and those sorts of things. Interestingly, very much like they did with the offsetting regulation that they introduced in response to the work pack case, they have also, they being the federal government, have also introduced a bill such that if it is passed. It's not going to get passed in the next few months with everything else obviously going on in the political scene at the moment. But if it gets passed, and I imagine that the Labor government would pass this if they come into power, the casual conversion rights will be extended to all employees covered by the Fair Work Act, not just award-based employees. The bill's yet to be released, as I said, so we're all in a bit of limbo in relation to that. There has been a little bit of negative publication or media around this, particularly from business groups, but I tend to take the view, for what it's worth, of it's probably really just stating the obvious in the sense that those people who would be able to seek to convert to permanent employees are really not casuals anyway. They have permanent employment. They've reached the, or they've gone beyond the qualifying period for the purposes of being able to run an unfair dismissal claim. They're not going to accrue rights on a pro rata basis in New South Wales, at least, until they get to 5 years, whether they're permanent or casual, in terms of long service leave. It would reduce your weekly payroll budget, although you would be accruing paid entitlements. I'm struggling to see the downside of the conversion laws for businesses. I think it will actually make it easier for them to manage their workforce in real day-to-day terms by having fewer long-term casuals. True casuals who are working irregular hours, no fixed roster, no firm advance commitment, still have a place in our business community and in our labour force, but that's not really what any of these laws are seeking to change or address. It's all about giving people certainty and security around their engagement and their financial commitments, and encouraging them to take rest and recuperation leave, like your annual leave, and staying at home when they're unwell because they're going to get paid sick leave, but not necessarily causing a financial disadvantage to businesses. So I think if managed properly, it actually will be quite a positive thing for businesses. On another front, in terms of positive things for our society generally and our workplaces, is the introduction of family and domestic violence leave. So from 1 August 2018, Modern Awards introduced this type of leave, and then to introduce consistency across all of our national workplace system, it was also introduced as a type of statutory entitlement, statutory leave under the National Employment Standards on 12 December last year. So we now have a new type of leave as of 12 December for everyone, earlier for Modern Award covered employees, that provided for the ability to take some time off when dealing with family and domestic violence leave. Conceptually, that's a wonderful thing, but as they say, the devil is always in the detail, and the problem in managing some employees some of the time is the possibility or scenario where this type of leave is abused, and the law tries as best as possible to deal with that, and I do have some comments that I'll make in a few minutes about that, but it is, like anything else, something that will have to be proactively managed by employers. So what is the new leave? Well, it provides for 5 days of unpaid leave for every 12-month period of employment. It is something that can be taken in a continuous block or in shorter separate periods of time. So if somebody had to leave early or come in late or something like that, they could potentially use the family and domestic violence leave if they satisfy the other criteria. It's a little bit like the old state-based award sick leave, where you just get the full entitlement as at your anniversary of employment. You don't accrue it on a pro rata basis like you do with sick leave, or which is now obviously personal/carers leave, or annual leave. You get it straight up as a full entitlement at the commencement of each 12-month period of employment. It applies to all employees, no matter their employment status, so full-time, part-time, or casual. And it does not accumulate from year to year. So you will not get a personal/carers leave style scenario where you could have people having tens and tens of days accrued that then they just use in a questionable fashion. It expires if it is not used. So that is a positive from a theoretical point of view. When can it be used? Well, an employee can ask to take that type of leave to deal with the impact of domestic or family violence if it is impractical for them to do so outside of their ordinary hours of work. They define family and domestic violence as being violent, threatening, or otherwise abusive behaviour by a close relative of an employee that seeks to coerce or control that employee and causes the employee harm or to be fearful. So that's a fairly broad definition. And of course, it is very, very difficult to put a definition to the concept of family and domestic violence, because as we all know, domestic violence doesn't necessarily need to be physical. It is often psychological. And therefore wrapping a definition around it is very, very difficult. So it is therefore, because it's difficult to define, subject to potential abuse. Now, in that regard, just like sick leave, compassionate leave, community service leave, those sorts of leave under the Act, employees who wish to use the leave need to comply with the notice and evidence requirements under the Act. And that basically says that they need to provide as much notice as is reasonably practicable in the circumstances of the need to take the leave, and the employer can, if they wish, require the employee to provide evidence that reasonably satisfies the employer of the need to take that type of leave. So in a personal/carers leave scenario, that's your good old sick leave, your good old medical certificate. This type of evidence is obviously going to fall more towards the category or the type of evidence or type of scenario that you might have with a compassionate leave scenario. You will obviously have to be very careful as to whether or what type of evidence you require from the employee. It's quite rare that an employer would ask an employee for a death certificate or some other type of documentation to prove the need to go to a funeral to take that compassionate leave. But you could, if you thought there was something suspect about the request, you could request that type of evidence, and that is the same here. So if there is a need to attend on the police station or the hospital or to go to the school to talk about arrangements with children, you could require some sort of evidence there. And compassionate employers are obviously not going to do that in genuine circumstances. This is only going to become relevant if someone is suspicious of the person's pattern of use of this type of leave, or things don't necessarily add up and employers may suspect that somebody is abusing it. Now, interestingly, and in one sense understandably, but in another sense very difficult to actually manage, is the obligation of employers to take steps to ensure information relating to notice or evidence or use of this type of leave is treated confidentially as far as is reasonably practicable. So from a practical point of view, that's going to be something that employers need to have a bit of a think about. It's important to note that the obligation of confidentiality does not prevent an employer from disclosing information provided to them if it's required by law, so for example under subpoena, or if it is necessary to protect somebody's health or safety. So if you were told of something where you think that somebody is likely to be put in danger or is in danger, and you breached confidentiality by contacting the police or docs or something like that, then the employer would be protected for that disclosure. Some practical issues really to round off our time today in relation to this particular issue that employers are really, in my books, going to have to figure out a way through. Leave is typically requested by using a form. A form therefore creates a paper trail. There is also then the issue of who sees and processes the forms at the time, and where is that form stored and who can see it historically. So there needs to be some very careful consideration around who can and should be able to access those documents, both from an HR management point of view, but also, of course, for the purposes of processing payroll. Even the form itself needs to be given some consideration, because often forms will say what type of leave it was. And even if you have, all the different types of leave and then other, it's still pretty obvious the type of leave that is being taken or requested to be taken. So there's then the issue of confidentiality around that as well. You need to record it in terms of how many days or hours have been taken, so you can monitor and manage it. So it's not a situation of just not recording it at all, because that will lead or encourage abuse, because employees will figure out you're not keeping track of it. But you then need to think very carefully of, well, exactly how are we recording the use and or non-use of this leave in our system, and who can see that. You need to be careful and considerate about what, when, and maybe if you request evidence of the need to take leave. And it's like everything. The 80% in the middle is fine, obvious, clear in terms of people's need to take it. It's the 10% at either end that you need to be careful of. The 10% of people that will abuse things, and then the 10% of people who probably should be taking the leave but aren't. So it is a difficult thing to manage for employers, and there's certainly no one-size-fits-all answer. You're then going to have a think about storage of HR and payroll records, and how, when leave is taken, it is actually communicated to the other staff. Now, in some workplaces, employees, colleagues are very close with each other, and they're going to know already. They'll probably know before management know. But there will be other workplaces where that's not the case. So there again needs to be some careful consideration around, well, how do we communicate their absence to other staff, and would that in itself constitute a breach of the confidentiality obligations? So there are a few complexities around complying with those obligations and providing that type of leave for employers. And as always, it just gets harder and harder and more complex for us to all run businesses in these modern times. But the need for this type of leave is pretty obvious, and subject to it being managed properly will of course be quite a positive thing for our workforce and our communities generally. So that's the wrap on family and domestic violence leave, and something that you'll all now need to be mindful of and put systems and procedures in place for your businesses. And it also brings us to the end of today's webinar. So I'm almost bang on an hour's worth of time today. So I'm sure that there's plenty of you that need to get on with the other things within your day. But if you do have any questions, by all means, please punch them into the Q&A panel on the webinar function there, and I can spend a few minutes answering those questions. Of course, if you think of any questions later on, or you have something that you might not want to share on the Q&A dialogue box there, by all means, please feel free to contact me directly. I've got my contact details up on the screen there. By all means, please either give me a call or send me an email, and I'd be very happy to have a discussion with you about that particular issue. Otherwise, I'm just waiting to see here if any questions are popping up. Thank you for taking the time to join us in today's presentation. I hope that you found it interesting and informative, and that there'll be a few things that you'll immediately be able to apply within your business and employment practices. We will be sending you a copy of the webinar, so you can have another look at the slides as a bit of a resource for yourself if you need to, and by all means feel free to share that with colleagues or anyone else that you think might benefit from it. Thank you for attending today, and unless we get a question or two in the next few minutes, we'll wrap things up. So, okay, we do have a question here. So the question is, do all casual employees need to be paid 25% loading? Okay, so the answer to that question is, in short, yes, depending, of course, on their role and the type of pay that they're receiving. So all modern awards and the federal minimum wage sets out that casual employees need to be paid the 25% loading on their base rate of pay. However, it doesn't necessarily mean that it's going to always be necessarily expressed that way. You might negotiate a rate of pay, as was, for example, the case in Mr. Skeen's circumstances, that he was paid well above the award rate, and he was just paid, I guess if you put it in inverted commas, a salaried type hourly rate, which was well above the award plus the 25%. So he was already in effect receiving that 25% loading. The problem that landed them in, though, by not categorically setting out how the rate of pay had been calculated and what amount was being paid for the purposes of them not accruing, or in compensation for them not accruing paid entitlements, was that they ended up with the double dip situation of him actually being held not to be a casual and having to pay some statutory entitlements on top of what was already effectively a loaded hourly rate. But the short answer is yes, all casual employees need to be paid the 25% loading. Okay, we've got another question here. So there are a number of firms offering HR management for SME clients with regular updates and visitations. Your views on external HR management services, please. Yeah, sure, absolutely. They vary. They vary widely. There are some very, very good services out there, and then that do provide good value for money. And then there are ones that, and I'm not going to name names, and I'm certainly not here to say negative things, but there are certainly service providers out there where there is not a great deal of value for money, and certainly over time it's a sliding scale of value for money, insofar as once you've got maybe the template style documents and policies and procedures that they provide, beyond that the value diminishes very quickly. And when you do the calculation of what you have to pay, because they'll normally lock you in for, say, a 12-month term, what you end up paying over that full 12-month term ends up being a fair bit more than what you could otherwise pay a specialised employment lawyer to prepare those documents for you. And the quality of the documents that you'll get from the lawyer, if they're a specialist in this area, will far exceed what you get from those sort of online HR providers. But it does vary. For example, there are some very good industry associations that have some very good employment lawyers on their panel, and you get a certain amount of hours per month or per year that you can get advice from. But unfortunately, it does vary widely. To be quite frank, a lot of the HR providers are getting their contracts from lawyers in the first place. So you've got to question whether or not it's worthwhile just going directly to the horse's mouth and getting the document and getting it drafted specifically for your needs. Yeah, absolutely. Yeah, you just need to tread carefully. Sometimes you need to shop around. Sometimes you need to read the fine print. Another question that has popped up is, in a tutoring college, they expect you to be regular part-time by working the required hours during the term, but not getting any pay during school term. Break, hard to work. Hard to work out whether part-time or casual. 15 hours required a week. No leave, loading offered on weekends. Okay, so there would definitely be, in the education sector there would be an award that is applicable to you. And the other element there is you need to determine whether or not it is a state government employee, whether you are a state government employee or not. State government employees are not covered by the Fair Work Act or modern awards. They have very specific pieces of legislation, like the Public Sector Management Act, that apply to employees in the New South Wales Public Service. So they have some very peculiar laws and rules around all of that. If it is a private practice, you need to look at the specific award in terms of how they're engaging you. Probably something a little bit beyond the scope of what I could answer today in this webinar, but by all means, very happy to take that conversation offline if there's something further there that needs to be discussed. All right. Well, that's great, guys. Thank you very much for your active participation with the questions at the end there. Very much appreciated. As I said, we'll be sending you an email after the webinar with the presentation there, so you'll have that available to watch and or share as you see fit. Thank you very much for your time and effort. Keep your eye out for the next instalment of our webinars. We find that we're getting a lot of interest in doing these things. You can spend an hour or so of your lunchtime learning and keeping yourself up to date in relation to these sorts of things. So thank you very much for your time and enjoy the rest of your day.